All right, so we're going to move on to prosecution. Ms. Victoria from the Joint Border Task Force is going to take that session on prosecution. Let's clap a little bit harder for her, please. She worked hard. We welcome you. Thank you so much. Thank you, Steve. That was an excellent presentation.
Good morning, my Lords, Honorable Justice Madubelu, Federal State High Court, Criminal Division 2. We're pleased to have you here. Good morning, my good fellow colleague. The topic before this morning is legal framework for combating trafficking in persons, increasing successful prosecution, best practices in prosecuting trafficking cases. I am Oburohi Victoria, an active Jbtf prosecutor. That's my phone number. The task of fighting trafficking cases, the issues of human trafficking is very enormous, and fighting the issue has to do with everyone, it's everybody's responsibilities. So, and if you think as a prosecutor you can act independently, you got it wrong at that aspect. And if you look at it, you cannot say, I'm a prosecutor, I'll just sit down and allow things just go on. You need to work with the investigators, you need to work with the counselors. As a prosecutor, there are certain things that you need to know. You are expected to display a high level of professionalism. You are expected to be transparent in your dealings. You are expected to be credible. And also, you must know the legislation. When I talk about legislation, I mean the Constitution of the Federal Republic of Nigeria. You also have to know the Trafficking in Persons Prohibition Enforcement Act 2015. You also have to know the Violence Against Persons Act 2015. You also have to know the Child Rights Act 2015 as well. You also have to know the Evidence Act. You must also know the Administration of Criminal Justice Act 2015. Why do you not have to study this? You cannot say as an investigator, I am not a lawyer and I can't just start going through law reports and all that, or law textbooks. You need them because they will guide you in the process of carrying out your investigation. And I'm pleased to inform this honorable house that in Jbtf, what we usually do is we have trainings often, and in those trainings, the prosecutors and the investigators are usually together in the course of the training. Now, the lecture is going to be divided into two aspects. The first aspect, we're going to look at the legal framework for combating human trafficking. We all know that this is a global issue, and NAPTIP didn't just come on board. It was as a result of the United Nations Convention as a result of the Palermo Convention in 2000, and where the United Nations Convention against Transnational Organized Crime was adopted, and the protocol supplementary it. And when the federal government came, next slide please, and we have other legislation internationally, but we're going to interest ourselves more on the United Nations Convention on Transnational Organized Crime that resulted to the enactment of the Trafficking in Persons Prohibition Enforcement and Administration Law 2003, and it was amended in 2005. And in 2015, that same law was repealed. And presently, we are using the present law. Can you please? I'm sorry about that. Presently, the law enforced now is the law promulgated on the 26th of March 2015. But you may be wondering, could it be that, okay, an offense happened in 2010? Are we just going to let it go? Or somebody come to report and said, I was trafficked in 2010 to Italy for prostitution. The beauty in this particular law is there's a section that is saving and transition provision that has created room for that. As a prosecutor, what you need to file is to make reference to the law of 2005 that is amended. You just can't allow, because it's an offense that has been committed, and the law, thank God, there's a section to that to address that. And again, this particular class, at the end of it all, I would like us to understand the law as it works, in the sense that we're going to take it session by session. We're going to dissect it and know what and what is expected as a prosecutor, and an investigator. So as an investigator, when you're in the field, when you're collecting your evidence, these are areas that you should look into. Sorry, can you? Okay. Now, this is the definition of Trafficking in Persons Act. That's the definition. I'm sure you have seen it. I'm sure we all have a copy of the law. There won't be need for us to go into it. Second, the next slide, please. These are the elements of the offense. In any case you are investigating, or in any case you are doing, these are the elements you must look out for. There must be action, there must be means, there must be purpose. And the purpose must be exploitation. Exploitation, some person will say, okay, you haven't gotten to Italy, you haven't gotten to Spain, you've not been exploited. And in most cases, probably if you just decide to just let it go. But in that case, I would say that justice has been done. The victim will feel so bad because setting out, you have already induced the person, or you had induced the person, or probably you had coerced the person, and just because it didn't get to the destination does not mean that offense has not been committed. It's been exploited, and that's just it. If any of these sections falls into the what you have, you can proceed with any of the section, and I'm sure we'll fly with that. I'm sure my Lord I'm sure I'm okay with that, my Lord. We look at the offenses and the punishment under the Act 2015. The Act provided from 6 months imprisonment to 7 years imprisonment, and a fine between 100,000 and 10 million naira. The beauty in this law is that there's no option of fine. Both fine and imprisonment has to go together. Next slide, please. Now we look at section 13 of the Trafficking in Persons Enforcement Administration Act. It prohibits all forms of human trafficking. Under this particular section, we will look at it in a scenario where there's an omission for you to prevent an offense from being committed. You'll be found guilty, the person will be found guilty on it. Then also when there's somebody who has assisted or participated, the person will be liable as well. And you also talk about consent. Some persons will say, she consented, the mother was even aware, the parents they gave consent, the girl in question gave consent. In fact, she's even an adult, she's 20 years. The law prohibits that. The law says that if any of the means is found in inducement, abduction, if you can trace to a person who is an adult, when you talk about adult from 18 years, it then means that an offense has been created, has been committed. Then when you talk about a child who is under 15 years, under 18 years, well, in the course of the findings and there's no miss, it just the act and the purpose. The law says that the person is guilty of the offense. We talk about under section 13. The punishment for that is 2 years and a fine of no less than 250,000 naira. Under section 14 of the Act, the exportation and importation of persons into Nigeria or outside Nigeria for labor or sexual exploitation is also an offense, and the punishment is 5 years and a fine of no less than 1 million naira, a term of no less than 5 years, and a fine of no less than 1 million naira. Section 17 talks about, Section 18 talks about a person who organize or facilitate foreign travel for the purpose of prostitution is an offense, and the punishment is a term of not less than 7 years and a fine of not less than 1 million naira. Section 20 talks about the person who procures another person and is involved in removal of human organs or buying and selling of human organs is an offense, and is when it's convicted is for imprisonment of a term of not less than 7 years and a fine of not less than 5 million naira. The combined effect of Section 23 is that it's an offense for employing or recruiting a person for domestic use, domestic worker. When Millis it's really controversial to have a family member to live with me. No, the law does not frown at that. But what is expected of you as the guardian is to provide a word to an extent to which you will treat your own child. And again, the same sections, the same law says that, because if you look at it, the age at which we are talking about is under 12 years. And if you must have such a child under your care, what I have just said, if probably the child is being exploited, or there's an injury, or is exposed to physical, social, or psychological development that will cause the child physical or social and psychological development of the child is an offense as well, and is punishable to a term of not less than 2 years and not exceeding 7 years in prison without an option of fine. Section 24 deals with recruitment and importing, transportation of persons. This particular section is likely to treating someone like a slave. In most sections, when there's a scenario that you feel that what is the proper section I will come under, that's when we express this particular section. And the punishment is not less than 7 years and the fine of not less than 2 million naira. Section 27 of the Act talks about conspiracy. When you conspire with anyone to commit any of the offense stated in the Act is an offense. So the half of the offense that you section 24, if one is found guilty of conspiring to commit that act, if there is some conviction, the year will be not less than 3.5 years, or a fine of not less than 1 million, and a fine of not less than 1 million naira. Section 29 of the Act talks about attempt to commit any of the offense. Same also applies just the way it is in conspiracy. Then Section 31 of the Act has to do with body corporate. If anybody corporate is found guilty of any of the offense, it will also be liable to conviction. And same punishment under this same act for the committing of that offense. If for addition, Section 29, the corporate body is found guilty of it, the same punishment will apply to the organization or to the body corporate. We talk about Section 32 of the Act. This has to do with unlawful obstruction of officers of the agency. Peradventure, probably the investigator has a case to investigate. In the course of arrest, and they are intercepted or probably prevented, that particular section will be applicable to such person. And if I'm liable, is convicted to term of not less than 5 years and a fine of not less than 250,000 naira, or to both. Section 35 of the Act talks about airline operators, sea vessel operators, commercial tour, and the essence of this particular section is that you cannot say, I don't know, I wasn't there. Well, that is the more reason why, as an operator, as a vessel operator and airline operator, you have the duty to ensure that your vessel or your airline is not used for anything that will be termed as trafficking. And that's probably, if you notice, there are some organizations, some tourists, some vessels or vessel operators, and they usually sign and to discourage anyone using their airline or vessel for such activity. So far, we've been able to exploit this law, and we have been able to investigate about 3,863 cases so far. And we've secured about 355 convictions in court, and presently we have about 150 cases at 150 cases at the various stages of trial at the various state high court and federal high courts, as well as national industrial courts in Nigeria. We have also rescued and rehabilitated and counseled over 14,207 victims of trafficking. The second part of the lecture has to do with increasing successful prosecution, best practice in prosecuting trafficking cases. The outline, like I said before I start my lecture, fighting human trafficking needs collaborative effort of everyone, not just at the national or state level, but among officers. I stated that there's no way a particular section of an organization. That is the reason, and that was what informed a situation where we have to form a case team to investigate a case. And then most times what we do is, once a case is reported, the investigator, the prosecutor, and the counselor ensure that there is proper investigation in that case that will lead to successful prosecution. And what that means is that the prosecutor is expected to direct and to guide the investigation. And again, once the case is released, the lawyer ensures that the due process and suspect and that of the victim is compliant. What we do first and foremost is to ensure that arrest and search warrant for the suspect, we get it handled, the operation is carried out. Now I'm going to show the role of the prosecutor. I have just mentioned that you ask yourself, do I have the power to carry out my duties? Yes, the law permits you that under section 12.2 of the Act, that you can carry out the responsibilities that I've just mentioned. And what it entails is that in carrying out that responsibility, you must ensure that all documents in the file is studied. You just cannot carry a file and just flip through it, because you may just decide to flip through one particular document, and that is the most important of it all. So what it means is that you must, from page to page, you must ensure that you study the file. Then you also must carefully study the case and ensure that the section of the Act that you intend to rely on, intend to use, whatever is needed is in compliance with your evidence. Then, for instance, I want to come up with, there's a likely case of organizing foreign travel. And then you, as a prosecutor, you have to look at it. Are the elements there? Can I deduce act here? Can I deduce means? Is there exploitation? To what extent have they gotten to? You must be able to marry the evidence you have with the relevant law. And you also ensure that the statement is taken in the language that is known to court. It's usually used English language. But in a scenario where the suspect has informed the investigator that I cannot write in English, I do not understand English, what is needed is for you to get an interpreter. And the translated version must be in the file. The original statement must also be in the file. And as a prosecutor, you must tender both in court. You must also ensure that you must also ensure that the investigator is advised, where possible, to obtain relevant evidence, such as medical reports. Then perhaps you can also ask for further investigation to the property of the suspect. In this area, we term it financial investigation. You can also request for probably if there's a case where there's juju, maybe the victim was taken for oath taking and all that, you must also advise them on how to go and revoke the oath and get the item that you use. In most times, probably you have their, whatever the native doctor collected from the victim will be in the shrine, you get that. And if you feel that there will be need for the any other persons involved to be arrested, you also direct the investigator to do it. And as prosecutor, it's not proper. You do not have business in going into investigation. Your duty is just to direct and advise. Then you request of investigation to be conducted when and when necessary. That's if you feel that after going through the file, there are areas for further investigation. You should tell the investigator, this is the area I intend you to carry out further investigation. You also must prepare your opinion concisely in a simple language, not that you start using big grammar and English that anybody that picks the file will not understand where you are going to or coming from. It must be in a simple language. Your legal opinion must be reverted within a week. You'll be surprised that I didn't mention the counselor. The counselor is key in this aspect, in the sense that is under the and usually when they are rescued, they are in shelter. And what the duty of the counselor is with information, because the victim will be more comfortable with the counselor and devoid information that she or he was reluctant to give to the investigator. So whatever information the counselor gets from the victim, will bring it up to the investigator. And at the end of it, we'll have a close, tight case for prosecution. When you are done with all that, when you are done with investigation, you are expected to do your opinion and the next stage of it is to draft your charge. In drafting your charge, you should ensure that there is a prima facie case. Some persons will say, why must you proceed? There is no case here. Some will say, okay, let's try. There's no try and error. It's not there in prosecution of any case. You look at the file critically. You ask yourself, is the offense of human trafficking committed? Do I need to go on with it before you decide on filing a charge? And when you are drafting the charge, you must consider jurisdiction. Am I filing if probably the offense took place in Benin? And do I have to go to Delta State to file? Or do I have to go to Warri, Asaba to file? You look at the offense, you look at where the offense took place, and you look at the surrounding, whatever is necessary. Because if you decide to go to a wrong jurisdiction, the matter will be thrown out at the preliminary stage. It then is that all the effort from investigation to that stage will just, and at the end of it, you cannot say justice is denied. So as a prosecutor, you must exercise due diligence and be sure that when you are filing, and again, the law is beautiful in the sense that it gave us wide option. We can either go to federal high court or state high court. Peradventure, we have a case in Abudu, and we do not want to travel to Abudu to file the charge. What we do, simply go to federal high court, and that saves us the expenses and the risk of the road. The only expense to incur is if the victim is in Abudu with the family, we will have to bring her to the court to give evidence. Then we talk about the element of the offenses. We went through the sections of the law. You look at the section of the law. Probably there's an offense that has to do with section 18, which has to do with organizing foreign travel that will promote prostitution. You now decide to file under section 16, which has to do with sexual exploitation. It doesn't make sense. So you look at the elements of what you have. Sometimes they look similar, but look at the one that is very close to the section of the act. Then you look at the offenders, and be careful about drafting your charge. Then you look at his provision of the law. Then you look at the direction, the court direction. You do not act in isolation. They usually practice direction that will tell you what and what is expected of you as a prosecutor. Then the proof of evidence as well. You must front load the proof of evidence. At the end of your charge must have a heading. We must have the officer's name to know whose officer, which lawyer is filing this. Must have a designation, a signature, and date. Then you must also ensure that affidavit of compliance is disposed to by the investigator. The charge should be filed expeditiously. After filing an assignment, after filing an assignment, you must, as prosecutor, you must keep in touch with the court registrar and ensure you get a date for arraignment. Then you ensure that the copy of the charge and during the court and the date of the arraignment is forwarded to the investigating department, and then serve the defendant within a reasonable time. And when we talk about reasonable time, is 7 days to the fifth day for arraignment. You cannot have a matter tomorrow. You are serving the defendant a charge today. The defendant has every right to kick against it and say, I'm not going ahead with this case. The time is too, you didn't say give me enough or sufficient time to respond to the charge. Then you ensure that the investigating officer and the counselor are informed through separate memo when the case is coming up. The beauty in my organization is that both the investigator and the prosecutors are together. So sometimes we dispense with the issue of service and memo just to avoid bureaucracy. Just inform the officer in charge of the case, the investigator, please, the matter is coming up so. In fact, the investigator usually have their own diary, just as the lawyers. They follow up the cases. So you inform them that the matter you file and the date is coming up, this is the date, and the investigator will also prepare. The counselor as well will also prepare to get the victim and the witnesses to court. For those victims that have been united, because they're not expected to be in the shelter forever. And sometimes cases take probably like 3-4 years. They're not expected to be there. So sometimes they are united with their family. In that instance, you have to give at least 2 weeks notice for them to be produced and for them to be produced. Then you must have an open file, you must have a file, court file, where all that you need for that particular case is kept. The charge will be there. You must have your evidence, your proof of evidence is there. Your writing notes should be there to take proceedings. Then you ensure that the court file is properly endorsed. Whenever you go to court and you are back, whether the court sits or not, you are expected to take notes, endorse the back, the cover of your file. When you are drafting your charge, you must ensure that you observe the rules against misjoinder of offenders, and duplicity and ambiguity. They observe the front-loading procedure as provided for in the evidence. Next slide. Evidence act. Then when you are done with your filing and you need to do trial conference. A trial conference for a child is different from that of adults. A child, the procedure is that you must make the environment child-friendly, and you must be you must have a friendly disposition to the child. You must create trust and let the child be comfortable having you around. And you must let the child feel comfortable. And if the child feels that he or she needs the parents, the mother, auntie, or whoever, you do not unnecessarily keep the interview during the trial with the child too long. Like I mentioned, that when you are going to court, you need to go with your evidence act, you need to go with your Administration of Criminal Justice Act, because you do not know where periodic objection will be, you do not know where an application will be raised by the defense. You need to arm yourself with the necessary laws so that you can respond adequately and promptly. sometimes there are some application that is very simple, but if you're not a serious prosecutor, start asking for date, you look stupid before my lord and your colleague as well. Then you must know your judge, know how they operate, how they run their court. Then you must arrive court no later than 8:30 a.m. You can't start running to court. Court sits by 9. You can't start running to court when it's 5 minutes to 9. You should be seated before the court comes in. Where necessary, refresh the memory again of the witness before the court starts sitting. To avoid stigmatization or further stigmatization of victims, effort should be made to prevent disclosure of victims' identity to the public via camera, video coverage in course of prosecution of the traffickers and other legal issues. We identify this particular aspect as challenge to successful prosecution. We'll probably in due course we'll talk about it. Also, we'll take appropriate action to ensure that no prosecution witness is intimidated in court. Where there are some instances, the defense counsel will be asking, have you not been prosecuting before you were sent to travel, you were trafficked to Mali or wherever? As a prosecuting counsel, you must object. You can't be in court and allow such to happen. Because if you allow it, the witness will be so uncomfortable with the question and will lose confidence in you that you are not competent enough to take up the case. Then at least 2 lawyers, if possible, where possible, should conduct each case to ensure effective prosecution. The where defendant John bail, it is your duty as prosecutor to apply for bench warrants and bench warrant to be issued against him. And again, this also feature as one of the challenges. So we're also going to address that. They ensure that interlocutory applications are replied to and filed accordingly within stipulated time. Then at the end of trial, when judgment is delivered, it is your duty as prosecutor to ask for a certified true copy of the judgment delivered. Then we have some bottlenecks to successful prosecution. And yesterday we had under the judiciary and prosecutor group, we came up with some areas where we identify some areas where there has been bottleneck to successful prosecution. The chart here represents the areas where the lack of funds is the highest. Lack of funds. So, and as we have said earlier on, the fight against human trafficking is enormous and it's a big one and it's quite challenging. And then funds has been an issue. But for now, people, we're fortunate to have the Jbtf, but we're fortunate to have the modern day slavery who have been supportive. And I also want to look at the next one to it is threat, undue interference, intimidation. And in this instance, the victim, most times, sometimes they will be reluctant to want to continue with the trial. A victim who was willing at the onset, probably after threat from the defendants and his relatives, we decided to just end the trial by saying, I'm no longer interested, I am tired. And we have come to see a scenario where the victim will say, we come to court and tell court, I have forgiven them. In that instance, what do? And the victim is your material witness, and the victim has come to court to inform my lord, I have forgiven them, I'm no longer interested. And we have come to realize that most times, probably they have been interfered with, or probably they have been intimidated. And the law itself, the ACJA, 2015 section 352 of section 4, has empowered that in a situation where a victim comes and say through that he or she is no longer interested. And what the court is expected to do is to strike her the charge and discharge the defendant. And in that instance, justice has not been met. Because at the end of it all, probably, ordinarily, not because of the threat and whatever, that wouldn't have happened. Then we also looked at the next one to that is safety of the next one to that is delay in legal process. This particular instance, I'll go to marry it with the last that has to do with having more specialized courts, in the sense that we brought up this issue before the Honorable Chief Judge of Edo State, and that we needed specialized courts. And we graciously granted us 2 specialized courts to deal with our matters. And that has really reduced the incidence of prolonged trials. But in the course of the meeting yesterday, some persons actually mentioned that they will need for more specialized courts. But I think we'll discuss that when it comes to a recommendation. Then we're going to look at lack of facilities to take evidence in court. This particular aspect has to do with where a victim who is reluctant, a victim who is willing to come to court to give evidence. The victim is made to sit in the open gallery with the public and the defendant and his relative. And in that process, the victim is traumatized, re-traumatized by the court process. And what is expected is that the victim will not be comfortable with the trial. And times he or she comes to the witness box to give evidence. You see him, after preparing, after preparing and all that, the victim will get to the evidence that cannot talk. So in that case, that's another area that justice is being hampered. We will also talk about it, how to go about it. Then non-remuneration of witnesses. This issue is very rampant in the sense that there is no special fund for victims or witnesses, particularly witnesses. Because at times you call a witness, probably the medical doctor who examined the patient. If the doctor comes in more than like 3 or 4 times without any compensation, without any assistance. For instance, I have a witness that came in from Lagos more than how many times. The next is telling me, I can't come to court again, I'm tired. There's no fund for that. There's no remuneration. We'll have to look at that. Then the next one is changing counsel. Defendant, with in the course of trial, they will not change his or her counsel. But when it's getting to the stage of defense, defendant a new counsel will come and start asking for adjournment or for adjournment. They will also look at poor investigation, where a case is not properly investigated, or probably the investigator is not well grounded, in the sense that probably is not told the rudiments of investigation, or what he ought to have done, he has failed to do it, will also affect prosecution of cases. Then we talk about compensation for victims. This particular aspect, although the Act itself made provision for avenue for compensation of victims, but most times in the course of financial investigation, the suspect will launder the trafficking trafficking proceeds into something else. At the end of the investigation, financial investigation, you will find out that you are not getting anything for the victim. So the victim is left with nothing, just probably, and luckily for us at NAPTIP, we have NGOs, we have other organizations, and when I had a talk with the Chief Executive Officer of Panfanda Justice Initiative, and she told me the process that they adopted in rehabilitating and then caring for their survivors. I think if that we can take a step, a clue from that, and step up that aspect of compensation for victims, because she told me that not just the victim itself, but the family members, when the victims were taken care of, I'm sure that that particular problem is taken care of as well. Then we talk about there's also lack of quick evidence. When evidence are not promptly gathered or gotten at that time, or there's need for you to carry out an investigation, there's need for you to go to probably Onisha to get someone who witnessed or who have participated or who did one or two things. You deliberate, you probably the response is too slow. At the end of it all, the essential evidence you should have gotten from there will not be. So in that case, these are the issues. There are about 12 that we came up with. So, but we came up also with recommendation that for the compensation for victim, we also talk about the aspect of fine being given to victim and being awarded for defendant in place of imprisonment. We went through the law and we discovered that there's no section of the act that says that it should be for the option of fine should be awarded. The sections all stipulated imprisonment and fine. So in the case where a defendant is awarded a fine, pays to the government coffers and walk home, I feel that's a big challenge because the money didn't get to the victim of the crime. The government who is seated somewhere is being paid money that they don't supposed to have, they're not meant for them. So what we suggest in this aspect is that in a scenario where judgment is given and defendant is sentenced to imprisonment and a fine, the court should also order that the fine should be paid into the Victim Trafficking Trust Fund for the purpose of, for that particular victim of that case. Then I also look at undue interference. This particular instance where the defendant comes up with that the victim has forgiven me, that I'm no longer doing case because you threatened, you intimidated, and cause undue interference on the victim. I feel my suggestion in this area should be that there should be avenue where a restraining order should be given to the defendant and his family members, and also to ensure that not all cases should be withdrawn from the court. Particularly cases that are grievous. When you talk about the offense of human trafficking, is an offense against humanity. I don't think it will be right for a case that has been filed, trial is ongoing, the defendant will come up and say, I'm forgiving them, in as much as she has the right to withdraw from the case. But then we should know the circumstances, and there should be a procedure, not coming to an open court to apply orally for that. Then we also look at the issue of the changing of counsel. And this particular defendant changing counsel, this particular aspect can be taken care of if the defendant can be made to write probably at the onset of trial to front load what they intend to come up as their defense at the beginning of trial, and to be signed by the defendant, so that when the defendant changes counsel and says that, okay, I need time to study file and all that, I think I'm sure my law will be able to help us out on that aspect. Then I want to look at the area of delay in legal process. This particular aspect has to do with making frivolous application. And probably most instances these days, because of evidence at section 84 of the Evidence Act, most defense counsel will just raise objection. My lord, the statement is not taken voluntarily. And what is the reason? That he was intimidated, he was made promise, he was placed under duress, and all that. And in as much as you have taken the evidence in camera, you understand? But what the law says is that so long as the issue of involuntariness is raised, what is expected is for you to go into trial within trial. So, and that one will take another procedure. This section 84 did not cure trial within trial. It just minimized it. Then we talk about, I feel that for the two courts that we have presently, they are doing adequately well. We were able to see a scenario where it would have been if the courts were to handle human trafficking cases. Now, our matters, if you are ready with your matters, the courts are ready to hear you. There's no delay as to that, and it's asking for both courts. Now we have issued on the answers. Prisons where inmates escape from prisons were broken open and inmates escaped. Most of them are not coming to court. So now my laws have just plaintiff cases to handle. So if we are ready, I'm sure probably what we will suggest in this aspect is that if the Honorable Chief Judge of Edo State can just allow these designated courts to be taking human trafficking cases alone, I think that will do some magic. Then, safety of the victim. Then there's an issue where the defendant has scorned from trial. This particular aspect of it is quite challenging to successful prosecution in the sense that, in as much as the law, the ACJA section 3554 says that we can proceed with trial when the defendant escapes from court or jump court bail. But I feel that that is not adequate, because if by the time the defendant is absent from trial, judgment is delivered, who serves the punishment is just there. And the victim will just imagine what happened. The suspect is not there, because you had the expectation that at the end of it, that I'll get justice. If at all, the defendant is probably asked to pay fine, the defendant is not there, how will the victim get the fine? So that is the case. So in the concluding paragraph, I've just said that the fight against human trafficking requires multifaceted approach as it involves the commitment of the government of the country to enhance the enabling law. What this entails is that it needs everyone's effort, and I'm glad that His Excellency came up with a law on trafficking in persons, and it happens to be the only state in the Federation that has the trafficking in persons law. And I'm glad that the members of the those state task force, they are here. And I'm sure after this presentation, we'll look at areas where we can better collaborate, areas where we can better harmonize our efforts to achieve success. And again, like the panelists, they also said the fight against human trafficking is everyone's effort. And you cannot say, I am the best, I am up there, I do not need help. We all need help. For NATIP, we are available anytime, any day. The doors are open. You need training, and you need training, because the law, the crime of human trafficking is different from other offenses, other crimes. And from the introduction yesterday, we got to know that those deployed to those state joint border task force, those state task force are from the Nigerian Immigration Service, the police. Yes, we give it to them. They are good. They are seasoned operators. But it is in as much as you are good in your areas. When it comes to the issue of human trafficking, it's unique in the sense that the aspect of your crime is quite different from the normal one that you know. So what that means is that you need training and retraining on human trafficking, so that for you to effectively combat it, you need to continually remind yourself of what is expected. Thank you very much for listening. Can I have questions, please?
Good morning, everyone. I am okay. While you talk about conversation of written, I want to refer to testify of that paper to conversation or also the things are not very for conversation on behalf of the victim while the trial is still ongoing. At the end of the day, when judgment will still talk about it, and most of the judges will grant complication to the victim. So the other point I go to the government workers that this one requested for enforce those to the victim. Section 65. Thank you very much.
Hello, good day, everyone. On that section 65, you made mention of only to be forfeited assets of the trafficker. So, if in the course of the trial, you are not able to make the assets of the trafficker to be forfeited, you cannot make that application in to award damages to the victim. So he said the section provides it should be for the forfeited asset of the trafficker.
Good morning, all. Actually, the revocation of oaths for victims is majorly done in joint operation with counselor and rehabilitation officer and the investigator officer. What we normally do, we take the victim to where the oath was taken, to have the confidence that all those things collected from her have been retrieved back, and whatsoever she has as fear or he has as fear in her mind will be broken. The process they followed when they started taking the oath, the same process they also do when they're taking the oath back. For example, if a victim said before, like the scenario of yesterday, that I happened to play the role of a suspect, that I took the victim to a shrine, that private PMs were collected from her, and she was asked to take some flesh of tortoise or whatever the animal they used to instill fear on her. So she traveled to Dubai. When she returned back, that fear is still on her that we might harm her again. That's where the head of counseling, the regional officer said, you have to, first of all, what they do, they will counsel the victim that, look, whatsoever you think that will make you want to open up will be reversed. Especially the oath taken. The same way we will take the victim back to the shrine. We have done that several. We take the victim back to the shrine. Those things that they did before when he was traveling will also be reverted from there to they have the belief that they are free.
In addition to that, it's not enough cases to take the victim back to the shrine. Because the native doctor usually is arrested alongside the suspect. And in the course of in trial, when we intend to go to trial, sometimes we use them as prosecution witness to corroborate whatever the court. The native doctor request to revoke the oath would provide if the victim agrees that I'm okay, you decide it's the victim's right. If she says I'm okay, I'm a Christian, I do not believe in that oath anymore, there will no need for us to further access with that. It's the belief of the victim that will determine whether we need to go for oath revocation or not. Thank you.